Hello and welcome. This is Roger Royce with the 10,000 Startups Podcast. And today we're going to talk about the One Big Beautiful Bill Act, OBA, and how it applies to startups. Now, this bill was enacted into law on July 4th, quite symbolically. Here it is, July 23rd. I've taken a little bit of time to talk about it because I wanted to see a little bit of what the fallout is, what the commentators say, and also it is a big bill. So it's taken a little while to sift through it and figure out what does actually apply to startups. So for about 15 minutes, I'm going to give you the high level of the provisions most likely to affect you. The biggest one, and the one you've probably heard most about, has to do with qualified small business stock. This is a big change. Now, as you know from watching our prior podcasts or listening to our prior podcasts, QSBS is one of the biggest giveaways the startup community has. What it means is that a stockholder, including a founder or an investor of a startup company stock, can avoid paying any federal tax at all on gains from the sale of that stock, up to $10 million or 10 times their cost basis in the stock, provided they hold that stock for 5 years. And provided that what they have is stock in a qualified small business, which means a lot of things, but mostly it means something with less than $50 million of assets. And that's a term of art, that 50 million. It's cash and tax basis assets. Now, here are the changes that have been made. For years, we've had this problem where somebody they start their company, they hold their stock for 4.5 years, and then they get a big opportunity to sell it. And, gee, do we sell it now and pay capital gains tax, or do we wait 6 months, meet the 5-year holding period, and pay zero federal tax? Well, it seems like one heck of a cliff and one big decision to have to make that now phases in. So a founder holds stock or an investor for 3 years and then sell, they get a 50% exclusion. If they hold for 4 years, they get 75%. If they hold for 5 years, they get the full 100%. Big difference from that all or nothing 5-year rule. Second big change is that it's no longer $10 million they can exclude, it's $15 million. And it even gets higher because it will be indexed for inflation starting in 2027. And then finally, there's an expanded eligibility. It's no longer a $50 million test, it's a $75 million test. So as long as the company has up to 75 million in gross assets, it can issue QSBS. Now, keep in mind, this acquires to stock acquired after July 4, 2025. So if you've got stock acquired before that, you're stuck with the old rules. But for stock after that, you've got these new expanded rules. The second biggest thing in this bill for startups is R&D expenses. You may recall there was a time in this valley and in this country when domestic research and development costs, any research and development costs, could be fully deducted. So since 2017, domestic R&D, that means research and development that has been developed in the United States, had to be amortized over 5 years. That means that you don't get a deduction today, you get it ratably over the next 5 years, even though you pay for the cost today. If that R&D was outside the US, the amount was capitalized, meaning you don't deduct it today, it just sits in an account, and it gets deducted ratably over 15 years. So the new rule is that R&D costs can be fully deducted. This is something that Silicon Valley tech companies lobbied for heavily, and every accountant in this valley knew about this and was unhappy about it, and it made big differences for companies that actually were profitable. So this is a big win for tech companies in the valley. And there are some transitional rules. Companies with less than 31 million in gross receipts can go back and amend their prior returns back to 2022, get these expenses immediately. And keep in mind that it does have to coordinate with the R&D tax credit under Section 41, which has always been the case. Next one, this might not apply to you. This is for companies that are profitable and have tangible assets that are subject to depreciation. So bonus depreciation is now been made permanent. Now you're going to hear that clause a lot under this bill. They say that the Tax Cuts and Jobs Act provisions that were enacted for a 10-year sunset, meaning that they expire after a certain amount of time, are now made permanent. All that means is that the sunset's been removed. The next Congress can come along and change all of this. So it's not permanent in that sense. It's just that you can plan on it being there for a while because it's not going to automatically sunset. So bonus depreciation for assets placed in service after January 19 is now made permanent. That means businesses can deduct the full cost of these assets. You don't have to capitalize them and depreciate them over a period of time. You deduct the full cost if it's certain type of assets. Significant for this valley is computer software, machinery, equipment, and then several other classes of assets. I just want to mention that you'll find companies now doing probably more what we call cost segregation studies, because they want to, when you buy an asset, you buy a group of assets and you want to separate out each separate asset and see if it qualifies for this full bonus depreciation. Similar to that, and this has to be applied first actually, is what we call Section 179 expenses. And that's a deduction that is different than bonus depreciation, but it's deduction based on property placed in service after 2024, and a part of the qualifying purchase is immediately deducted rather than capitalized and depreciated. And this is a little more complicated because it's the maximum deduction is $2.5 million and it phases out. And you can see my chart there, how this phases out. But keep in mind, it applies to some software, applies to machinery and equipment. So if the qualifying purchases exceed $4 million, which is an increase in the prior cap, then it starts to phase out. Now, that sounds a lot like bonus depreciation, but it's different and there are coordination rules. And I've got a chart here that shows how. So bonus depreciation, of course, is 100% of qualified assets, and it applies after Section 179 because both these reduce basis, right? So first you do the 179. If you got any basis left, you can take bonus depreciation. The Section 179 deduction has a cap that phases out. Bonus depreciation is just subject to income. The dollar limitation is none for bonus depreciation, but 2.5 for 179. So you'll want to combine those to maximize the deduction. So this will be a big deal for companies that actually have income and have assets that are subject to depreciation. Similarly, for companies that have income and have a lot of debt, there is an interest expense deduction. Section 163J limits the amount of interest that can be deducted by a company to 30% of EBITDA. Now, EBITDA is somewhat of a proxy for income. And the change now is that we're adding back to taxable income, depreciation, amortization, and depletion. So effectively, we're increasing the amount of business interest that is allowed to be deducted. Section 199A deduction, for those of you that are formed not as a C corporation, but as a pass-through entity, sole proprietorship, partnership, S corporation, and LLCs, taxes, partnerships, or disregarded, there is a potential deduction of 20% of the business income from those entities. Now, that deduction was set to expire. OBA has removed the sunset, so it is permanent, as we say. And it also expanded through some fairly complicated de minimis rules as to who all can qualify for this. But basically, most business owners and most gig workers are going to qualify. This is a big deal. This is a 20% deduction of qualified income from these entities. Another difference that is worth mentioning, or another change, is the pass-through entity tax. You may recall back in 2017, the state and local income tax deduction was limited to $10,000 per year. So there's a workaround because some states, like California, allowed entities that are pass-throughs, partnerships, S corporations, to pay the income taxes that would have been imposed on the owners because it's a pass-through. It just reports each owner's share of income and they pay taxes on that income. So they allow the entity to pay that tax. And now it's a entity level tax and it gets passed through as a deduction to the owners and they end up deducting it they get a K1 and they deduct it as a separately stated item. So it bypasses this $10,000 SALT deduction. That strategy is still valid. There's some technical changes as to how it gets reported, but as a high level, it's still viable, even though there was a huge backlash against this. Both the Senate and House bills had provisions. They got at it differently, but they both had provisions limiting, restricting, or eliminating this strategy, but for whatever reason, did not make it into the final thing that got signed. If you are in the energy business, this was not a good day for you. July 4th was not a good day because here's a list of all the energy credits, numerous energy credits that simply were repealed. So we're going back to a system that rewards oil and gas, does not reward sustainable, new, or alternative energy. And I won't go through all of these individually. The one that's been in the papers the most is, of course, there was some talk about possibly getting a credit for buying electric cars. Yeah, the law went the other way on that. I want to mention opportunity zones. This is something else that came in back in 2017. And you may recall that, well, first let's talk about opportunity zones. This is the idea that they wanted to incentivize investment in low-income communities. So the idea was if an investor puts their money into a low-income community, of which there are 8,700 in the United States, and you'd be surprised what qualifies as a low-income community, they could get special tax incentives. And the tax incentives are that the investor could roll over or reinvest capital gains, not pay tax on capital gains from the sale of a capital asset if they rolled over or reinvested those proceeds into a qualified opportunity fund. And the taxes on those gains would be deferred until the end of 2026 or when the investment is sold. That is the that is the QOZ, the Qualified Opportunity Zone exemption. And there's also used to be a step up in basis that's gone. No need to talk about that. But if that QOF investment is held for more than 10 years, then any new gains while it's being held by the QAF would be tax free. Well, how did the law change this? This was set to sunset on 2026. In other words, the deferral of the tax, and that is now made permanent with a 10-year redesignation cycle. And there are several other changes that made this more attractive and expanded it. So keep in mind that the Qualified Opportunity Zone is still alive and well and is going to continue to be prominent in stimulating investment in low-income communities and qualified opportunity funds. Now, tax on carried interest, there's talk every year about taxing carried interest. What's that? That's the share of gains that hedge fund managers and venture capital and partners receive, general partners receive from their funds. And those are taxed at capital gains rates. There are all sorts of rules that we have to clear in order to get those capital gains rates, but suffice it to say that generally hedge fund managers of hedge funds and VCs end up getting capital gains treatment just like their investors. And there's always talk, that's called carried interest. And there was always been talk about taxing them at ordinary rates because it is very, very service-like. No changes, okay? No changes. There's nothing has been changed about that. The tax law, not the House or the Senate version, even touched that. Several other Tax Cuts and Jobs Act provisions were made permanent. The most significant are the reduced rates from 2017. Those are now permanent. Without this new law, they would have increased back to pre-2017 levels. There are several other individual exemptions and deduction amounts that have remained in place. The personal exemptions are personally limited, expanded child tax credit, which is indexed for inflation, alt-min exemption amounts, phase-out thresholds are permanent. I guess the biggest one on here is that the estate and gift tax exemptions are now really high. They're really high and they're made permanent. We may do a whole session on that. And then finally, with respect to this bill, I want to mention that you have to pay attention to the effective dates because they change. Typically with tax legislation, the effective dates tend to be after the date of enactment, but sometimes they go back to an earlier date because people see the law coming and they start planning into it. And So you'll have an early date. For example, for bonus depreciation, we have a January 19 date, but generally we have a July 4th transitional. So this applies to transactions applying after July 4. For assets or stock prior to that date, the old rules, or prior to those dates, I should say, the old rules might still apply. And a lot of these rules are going to require IRS guidance. Now, on that point, you probably heard that there's been a bill in Congress to slash the IRS budget even more than it already has been slashed. Another $2.8 billion. It is advanced out of subcommittee. It's still alive. If that happens, probably fewer audits. I don't know. Probably less service. Probably going to wait a lot longer to get your refund of your employee retention credit, stuff like that. But just keep in mind, legislation is afoot to restrict the IRS even more than it's already been. This is similarly not in the OBA, but it's worth mentioning that recently, just this last week, President signed the Genius Act into effect. This addresses the treatment and regulation of stablecoins. There's another, and that's big because that's going to give even more legitimacy to crypto, as this administration has done. And secondly, there's another act weaving its way through Congress, the Digital Asset Market Clarity Act. It's passed the House, it still has to pass the Senate, and that basically is going to define whether cryptocurrency is a commodity or a security. The reason this is significant is there's always been a little bit of confusion about whether something is regulated by the SEC or by the CFTC. Generally, this Clarity Act will provide clarity on that issue, and we actually will possibly see a different role for the CFTC. Let me put it that way. I don't want to say too much about it because who knows what the Senate will do to it. Okay, with that, I'm Roger Royce. I'm a partner with Haynes Boone in downtown Palo Alto, California. I do startups, emerging growth, and venture capital. This has been 10,000 Startups. Thank you for listening, and we will see you all next week.